counsel?
Yes, Your Honor.
Do we have Mr. Romero?
Judge, I'm sorry. This is Gerald Bradley from Public Defender. Just wanted to make sure you could hear me.
Oh, now I can.
Okay. Yeah, I just turned my mic on. I was a little confused on the teams. I just wanted to make sure I didn't interrupt your prior proceedings.
Oh, yeah, no problem. Okay, can you both announce for the record?
Thank you, Your Honor. Brooke Gahn on behalf of the state.
Gerald Bradley for Mr. Hayes appearing virtually.
Okay. Sir, state your name and date of birth.
Sencere Patrick Hayes, 10/31/2000.
Okay, can you speak up louder so you've got your attorney and they can hear you too?
Sencere Patrick Hayes, 10/31/2002.
Okay, sir, you have a Superior Court grand jury warrant, which means the grand jurors met, they heard testimony, they found probable cause on the following. 1 count of conspiracy to commit murder in the first degree. 1 count of murder in the first degree. Those are both class 1 felonies. 1 count of conspiracy to commit kidnapping. 1 count of kidnapping. 1 count of arson of an occupied structure, and 1 count of armed robbery with a deadly weapon. Those are all class 2 felonies. 1 count of theft of means of transportation, a class 3 felony, and 1 count of hindering prosecution, class 5 felony. Now, your attorney's on the line, and Mr. Bradley, you're from the Public Defender's Office, so I'm appointing you to represent him, correct?
That's correct, Judge. Thank you.
Okay. And Mr. Bradley, did you wish to be heard?
Yes, I did, Judge. I had 3 things I wanted to address. One might be short. I represent Mr. Hayes in what appears to be charges from the exact same set of events. CR 2024-008-003-001. In the documents the court sent to me, there's an indication that this particular case Mr. Hayes is here for now is a refile of an old case, and it's listed the 2024 case I just gave you. So is it, I just want to make sure my understanding is correct that 2024 case will be dismissed and this new case will now take over as far as how we go forward. If that's the case, then the first of the 3 things I want to address, I don't need to address.
Okay, and counsel for the state, do you have any knowledge about that?
Thank you, Your Honor. I think that Mr. Bradley is most likely correct, but obviously, as the court is aware, this court doesn't have the jurisdiction to be able to dismiss that other case, but I would anticipate that the assigned DCA for that, the CR 2024 case, will be making a motion to dismiss that downtown in the appropriate venue.
And I can tell you the notes that I have on this case from the pretrial services is this is a refile of the older case. And previously there was it looks like a $2 million cash only bond. So what I can write in this order is that this would not be in addition, but it would be a $2 million bond, which is what the grand jury judge set. But it wouldn't be in addition to the bond previously set.
And Judge, I did want to also address bond briefly.
Go ahead.
If the old case is going to get dismissed, then I'm not going to make any double punishment arguments or anything like that. But for the bond, I just asked the court to consider this. Mr. Hayes is indigent. He has a public defender, and he's had one since November, December. And Arizona Rule of Criminal Procedure 73B2B requires the bond to be, quote, the least onerous type of condition in the lowest amount necessary, end quote. Malone versus Superior Court 181 Ares 223 says, quote, bail set at a figure higher than an amount reasonably calculated to assure the presence of an accused to stand trial is excessive under the Eighth Amendment. And lastly, Judge, the Arizona Supreme Court also instructs, quote, in determining the amount of bail, that a court must consider the circumstances of each case. Well, Mr. Hayes does have family support and other things that in a release motion I would mention. I do just simply focus on his indigency status. A $2 million bond for Mr. Hayes is absolutely excessive because it doesn't comply with the Arizona rules or the Constitution, Arizona and the United States, that demand the least onerous necessary to secure his appearance. I'll leave it to Your Honor to consider lowering that bond. I would suggest $500,000. I am quite sure Mr. Hayes isn't going to go anywhere with that bond either. But $2 million is excessive for anybody. I'm a public defender. I've never had anybody who I've had a conversation with where I thought that was a bond that even made any sense to talk about. So when we're looking at the least onerous bond necessary to secure his appearance, $2 million is quite frankly, Judge, laughable for an indigent defendant. For someone that makes a lot of money, that's different. But Mr. Hayes, his employment history, he's worked places like restaurants, retail stores. He doesn't have any assets where he owns a house or anything like that. He has me here. He doesn't have a private attorney. So with that in mind, I would ask the court to consider making this a reasonable bond.
Okay, County Attorney, did you want to be heard?
Yes, Your Honor. The state would ask that the court affirm the grand jury warrant. First, as an initial matter, this is a grand jury warrant. The information, the factual basis for these charges, the current court is not aware of that. And so I think that it's certainly better and more reasonable for this court to follow the order of the prior judge at the grand jury, who was able to have some information regarding the underlying facts of these allegations. Obviously, these are all very serious felony cases involving a homicide and the actions that led up to that. So I think the court needs to consider that. I would point out to the court that in the factors that are enumerated, there is no specific reference to the court determining whether the bond amount is something that the defendant is able to afford to pay. Additionally, the factors that the court must consider are not limited to whether or not the defendant will appear for court. The court also has to think about the safety and protection of the community, the safety and protection of next of kin of the victim, as well as safety and well-being of potential witnesses, things of that nature. So I think given the severe nature of these charges, the fact that the court has limited information about the factual basis, and additionally that Mr. Hayes is facing very significant potential consequences if he is convicted after trial, even potentially the possibility of the death sentence. I think that bond request, that bond amount is completely reasonable and is the least onerous given the facts and the charges that are he's here before the court on. Thank you.
Okay, thank you. Sir, your next hearing is going to be an arraignment, August 1st, 8:30, counsel.
Judge, that works for us.
Okay. And I am going to affirm the bond of $2 million. Obviously, the grand jury judge did have a lot of information or was given information in setting that. I'm not going to second guess that. But also, I am familiar with this case. Given the nature of the charges, I think that bond is appropriate. Anything else from either counsel?
No, Your Honor, thank you.
Judge, I had one last thing, and I'm glad you're familiar with the case, so you probably know this is a very high-profile media case. There have been stories throughout the course of the investigation, and since Mr. Hayes was arrested on the other case, many of them, if not all, have been prejudicial and jeopardized his right to a fair trial. We sit here today with Mr. Hayes being given his second initial appearance on, albeit some different charges from the old case. Some of the charges appear to be the exact same, but they stem out of the exact same facts, events, and dates from the old case. So what probably happens here is the media, like they did last time, may try to get a hold of this case and put Mr. Hayes' picture up there again, which will cause more prejudicial coverage for him, make it harder to get a fair jury. And it's completely gratuitous at this point because, like I said, there's other ways to go about this. And Mr. Hayes has already had an initial appearance for at least the same set of events. So I would just ask that the court seal this hearing as we move forward with this new cause number.
Seal the hearing?
Yes, Judge, correct. Seal it in the sense that it can't be released to the public, so we can embrace Mr. Hayes's due process rights, right to a fair trial, and prohibit any unnecessary new images of Mr. Hayes. And I do want to add, Judge, this case has a mistaken identity defense that was noticed in the prior case, and there are also identification issues in this case. Detectives often ask if people can identify Mr. Hayes, and I can tell you from reviewing the discovery in the old case, we start to see witnesses saying, yes, I've seen him on the news, but, maybe they say I've never seen him before, but that starts to blur some lines with identification. So with letting the court know we have noticed that defense and that there are, in addition to the defense, simply identification issues in the case, the less times new images of Mr. Hayes are put into the public, the better. And he has a right to due process, and there's simply no reason that this particular hearing needs to have new images put into the public. The media can certainly still report on it.
Okay, well, that is something that you will have to file a motion. We are not a court of record on this. The only thing I can do is if you're requesting, I can seal the Form 4. Let me tell you, I have not read one thing about this case in the newspaper. My only familiarity with this case is that I believe I've done a number of warrants in the past. So I'm familiar with some of the fact pattern on this case. I have not read or seen anything in the paper. So I would entertain a motion to seal the Form 4, if you would like me to do that, counsel.
But that starts to blur some lines with that. Judge, I would like you to do that, but here's the problem. If you want me to file a motion to address this, it's going to be too late. By the time I file it, the state gets 10 days to respond. I get, my 3 days to respond or whatever. This is already going to be out there. And you're right, Judge. Now that you mention it, yes, you are in some of the warrants in this case. That does sound familiar. But that's why I think it has to be ruled upon now, because the media is not going to wait around for a briefing schedule.
Well, I don't think I can order the media not to report on a case that's a public record, and they have the right to appear in court. So, but I will, unless there's some objection from the county attorney, I will seal the Form 4.
Your Honor,
County
the state
attorney?
does not. The state does not object to you sealing the Form 4.
And Judge, can I just want to clarify so the court is clear on what I'm asking. I am not asking that the media can't cover this case. They absolutely can come to court, and I'm not asking that they can't. They can write an article about this new development, and I'm not asking that they can't. My focus is simply on the video and the images from this particular hearing due to the past prejudicial coverage and the identity issues that I've explained to the court. Does that make sense? I just want to make sure. I don't want the court
No,
to think I'm asking. No.
Yeah, and I think that that's a motion that would need to be briefed. I don't believe that I can order that portion of the hearing to be sealed in any way. I don't know. I mean, there's no media in the courtroom right now, but I will seal the Form 4.
And Judge, I would just make one last request. I believe you absolutely have the authority to seal this hearing, but if you don't feel like you can seal it permanently, I would ask for a temporary sealing so we can at least brief the issue. And then if yourself or another judge decides it shouldn't be sealed, then it could simply be unsealed. But if you don't seal it now, yeah.
Yeah, given the fact that you already have this case in another, I'm assuming it's assigned to a judge that would be familiar with this case, I think you could file a motion Monday on an expedited basis to see if they would seal this. But I don't believe that I can do that without any type of research or case law to support this.
Well, Judge, I certainly can do that. Another issue is, will the case even be in the docket for me to have a judge to e-file? It isn't now, but I'll check Monday. But I can tell you that in past high-profile cases I've had, and I believe in this one as well, these things tend to get published right away. But if that's the court's ruling, I'll do my best.
Okay. Anything else from either counsel?
No, Your Honor, thank you.
No, Your Honor. Thank you for allowing me to appear virtually. Unfortunately, I just found out about this at like 7 a.m.
Yeah, no problem. Especially on weekends, we're always flexible on that. And just for the record, I did seal the Form 4.
Thank you.
Okay. Get your paperwork from the court staff. Zachariah Benjamin, come on in. And then